Good evening to Karyn. Thanks indeed for your time. So it seems like authorities have gone after the top level of the pie. But, what they have to prove is that there was a clear corruption in this case and that there was an organized criminal enterprise intent on looting the bank, isn't it?
You're spot on, Griselda. And the reason we know that is that they've been charged with racketeering under the Prevention of Organised Crime Act. Now, racketeering carries with it a 25-year sentence. And essentially, it's that you are part of an organized criminal enterprise that is aimed at performing organized criminal activities. In this particular case, corruption, financial malfeasance, theft, particularly I think the issue of the municipalities being at the heart of that, but essentially not just a haphazard looting of an entity. This was an organized, controlled, and very deliberate campaign of looting that had terrible consequences for the poorest of the poor, according to the NPA.
Karyn, an investigation dating back to August 2018, but a long road to go to prosecution. That's something that the National Director of Public Prosecutions, Shamila Batohi, kind of stressed in today's earlier press conference. There are going to be quite a number of hurdles, one would presume, before this matter even reaches finality, whenever it does.
Well, as she pointed out, she said, the NPA wants to basically ensure that when they go ahead, they have all their ducks in a row, but they cannot control what the accused in this particular case will do. I mean, there's a huge weight of forensic evidence. A huge amount of work was done in terms of the report of Terry Mutau, a huge amount of bank statements. We know the level of detail that exists there. So, on that level, yes, a lot has been done, but the accused in this case are people who will be fighting the potential of a 25-year jail term. They may well choose to litigate in terms of various aspects of this case, in terms of access to information that forms the basis of the state's case against them. So there is a real possibility of protracted pre-litigation before this matter gets underway. And we have seen that illustrated in matters like the Jacob Zuma case. So while the state may want to get this underway, and I think they are ready to in respect of the 8 accused, that is not to say that this case will get straight off the ground.
Karyn, while authorities have gone for the top part of the pie, I guess one of the things to closely watch is whether politicians who have been linked to what's been referred to as the Great Bank Heist 2 will face the music over their alleged role in the collapse of this bank.
There are 2 points to remember here. These accused have been charged, the initial accused have been charged with corruption, and they've been charged with money laundering. Money laundering is the concealment of the proceeds of crime. Now, there have been allegations that a number of senior EFF and ANC officials were in the sort of, had their hands in the cookie jar or did receive payoffs, for example, in order to ensure that municipalities invested money that they should never have invested against the prescripts of the Municipal Finance Management Act in VBS. So when you see an offence like corruption and money laundering, it is a bigger crime than just, the 8 or 10 people that will stand trial in the immediate circumstances of this matter. Who did they corrupt? How were they corrupted? And how were the proceeds of crime concealed according to the state? This trial will be pivotal to exposing that. And I think the state will utilize it as a mechanism to basically ensure that they can get those political aspects of this matter out in the open.
Karyn, just the last one, the Constitutional Court declaring it unconstitutional for a private school to terminate a parent's contracts. That's another matter without proper justification. What impact will this have going forward?
Well, the people involved in the case, particularly Equal Education, have come out and said this is a massively important judgment because primarily it concerned 2 parents at Pridwin Preparatory School who had apparently behaved very badly in soccer matches and really not conducted themselves in an appropriate manner. And the school had summarily decided on the basis of the contract they had with the parents to terminate that contract, effectively expelling the minor children. Now, beyond the parameters of this case, There are a number of independent low-fee schools in this country. Independent schools are growing in South Africa. And, there can be circumstances in which, for example, a child may not be able to pay the fees only to have the contract substantively ended by the independent school. So it is a very important thing. This court has not given directives on how that can be corrected, but it is drawing a line in the sand and saying you cannot simply terminate a contract without a rational reason for doing so, and certainly indicating that the Education Department needs to take this matter in hand.
Karyn, I'm afraid that's all we have time for this evening. Thank you very much indeed for some clarification on both those matters. Senior legal journalist Karyn Maughan joining us via Skype. Another one of our top stories this evening, the ministerial